Good morning. Good morning. Wow, what a crowd for Saturday morning of NLC. This is excellent. Welcome to the third day. My name is Nate Kazmarek, and I'm Vice President and Director of the Practice Groups. It has once again been a jam-packed convention, and I'm very excited for the incredible day ahead of us. I've worked at the Federalist Society for the last 8 years and have now been a part of as many conventions. I was thinking the other day about how the 3 days of this conference roughly mirror the 3 years of law school. On day one, everyone shows up well-rested and eager to learn new things, ready to meet friends and colleagues. But just like wondering what will be on the final exam at semester's end, there's uncertainty about who the dinner speakers will be. You might have seen Justice Gorsuch coming, but I'm pretty sure Justice Breyer wasn't on your bingo card. On day two, everyone is less rested, but happy to have made it through with minds less full of mush and thinking more like a FedSoc lawyer. Caffeine, panels for CLE credit, and friends, old and new in the hallway, helping to propel you forward. By day three, a tiny part of you is very tired and wondering what you're still doing here, but you're having such a great time and you want to soak it all up to the very end before going back to the real world. I realize the analogy is imperfect, but there's no question that like my fantastic third year of law school, today's NLC lineup is arguably the best of the bunch. We have excellent panel discussions, more hallway conversations, book signings, a fantastic Rosencrantz debate on TikTok, and a thought-provoking Bork lecture, all still ahead of us. And I'm really looking forward to starting our day with the next showcase panel titled Sex, Gender, and the Law. Before I introduce our great moderator for this panel, I have 4 quick housekeeping notes and announcements for you. First, as noted on the back of all your programs, if you are seeking CLE credit today, please be sure to sign in and sign out. Second, if you haven't taken advantage of the rare documents exhibit this week, you owe it to yourself to stop by the Remnant Trust display in the Cardozo room before 5 p.m. today. Trust me, it's worth your time. Third, we have a slight change to our program this afternoon. The Bork lecture at 4:30 p.m. has moved to the International Ballroom, which is right here. We'll have reminders throughout the day, but please do make a note of that for later. Lastly, if you look on page 37 of the program, you'll see that this year, FedSoc has developed on-demand virtual CLE programs for our members. For the first time ever, you can view FedSoc webinars on our website at any time and gain CLE credit for it. We are really excited about this new platform, and I hope you'll scan the QR code in the program, which will give you more information about it so you can start taking advantage of this new CLE on demand for our members. And now for our showcase panel. We are very fortunate to have Jennifer Braceras guide this next discussion. Jennifer is a political columnist and former employment lawyer and news editor. A longtime senior fellow with Independent Women's Forum, Braceras founded the Independent Women's Law Center in 2019, where she was director until this year. She previously served a 6-year term on the U.S. Commission on Civil Rights and has taught courses on civil rights and constitutional law at both Boston College Law School and Suffolk University Law School. Please join me in welcoming Jennifer and our great panel.
So is everybody ready to talk about sex? I hope so, actually, because conservatives actually are often, I find, hesitant to use the word sex, even when talking about sex discrimination, as are, in my experience, most people under the age of 35 who have grown up going to gender reveal parties. Most people, I think, default to the word gender when they are talking about biological sex differences between men and women. But They really shouldn't do that. I would caution you not to do that. We'll talk about it more as the panel goes forward, why you shouldn't do that. But the main thing is that when we use the language, I think, of the left to talk about biological sex, we end up talking past one another. And when we're talking about the law, it's really important, I think, that we do use the word sex, because when it comes to equality of men and women, this is, an important factor. So gender, while related to sex, is not the same. I think Justice Scalia put it well when he said, gender is to sex as feminine is to female and masculine is to male. As usual, Justice Scalia was right. It's fine to use the word gender to describe sex-based norms or stereotypes, and likewise, the phrase gender ideology properly captures the latest incarnation of the movement to paper over sex differences. But this broader movement to, I would say, erase sex is not new. It's been around since the 1970s. The push for the Equal Rights Amendment, I would argue, was part of that. And certainly that movement has reached fruition in debates about allowing trans-identified males to access women's locker rooms, athletic competitions, and prisons. But those sort of subset of transgender issues are really part of a larger, long-time debate about whether the law should treat sex the same as race, and whether the law should recognize biological differences between the sexes at all or be just sex blind. So to help us parse all of those issues, we have a very distinguished panel of experts, all of who come at the issue from pretty different angles. I'm going to briefly introduce them to you now to try to situate them within the debate, and then because this panel is so expansive, the topic is so expansive, we're actually going to skip opening statements and just have sort of a roundtable discussion where I'll ask the panelists questions, and then the audience can join in with your questions. Okay, so without further ado, Professor Dorianne Lambolet-Coleman is a professor at Duke Law School. She is the author of On Sex and Gender, A Common Sense Approach. Although a Democrat and a supporter of LGBTQ rights, Professor Coleman, who is also a former college and professional runner, has testified in Congress against the current versions of the Equality Act, arguing that they would jeopardize women's sports, among other things. Erin Morrow-Hawley, my former colleague at IWF, is now a senior counsel and vice president at Alliance Defending Freedom. She's an expert in constitutional and administrative law and is part of a team at ADF that has secured 5 preliminary injunctions in different circuits against the Biden administration's Title IX rewrites. Commissioner Andrea Lucas is a Republican commissioner on the U.S. Equal Employment Opportunity Commission. She writes and speaks frequently about employment and civil rights law, including DEI policies, women's rights, religious liberty, and pregnancy discrimination and accommodation. Professor Sarath Sangha is a professor of law and co-director for the Center of the Study of Corporate Law at Yale Law School. He studies, among other things, the progress of women in the nation's accredited law schools, including the process by which women initially gained access to law schools and the extent of their progress in law schools since then. And finally, General John Sauer, a former federal prosecutor, served as Solicitor General of Missouri from 2017 until 2023. He's currently counsel of record for the leaders of the Arizona legislature in Peterson versus Doe, defending the validity of Arizona's Save Women's Sports Act, and he has recently been announced as President-elect Trump's next Solicitor General, so congratulations. So I want to start out with sort of a bird's eye view of the topic. And I think that when we're talking about identity politics generally, it's important to remember that women are fully half of the population, and we're not a discrete and insular minority, so to speak, like other racial and ethnic groups. And I think that's important to remember when we talk about how our anti-discrimination regime should treat sex. So I want to start off with Professor Coleman and Commissioner Lucas and ask them to focus on the statutory context and talk about how our statutes, Title VII and others, treat sex versus race, and whether, in particular, Title VII requires employers to be sex blind, and if so, why? If not, how? And all that stuff. So why don't we start with Commissioner Lucas?
Thank you. And I have to give my standard government disclaimer that because I am a member of a multi-person panel, I'm only speaking on behalf of myself and not the commission, not on behalf of any of my other commissioners. So sorry for that. Jumping in, I think it's important to look structurally that our civil rights statutes do not require employers or other entities to be sex blind. They often require them to be sex neutral, but not sex blind. And I think, as a preliminary matter, I think it's important to say that biological sex is real, and it matters, and it's immutable, and it's binary. And from that premise, that's the foundation on which we then proceed to have the various civil rights laws that have been enacted over the last 60 years. Title VII is my focus, so I'll talk about that, but you can see other areas where this is apparent, that we have sex neutrality where it is going to be necessary to ensure the equal treatments of individual going forward. But you also have sex acknowledgement. So structurally, for example, for Title VII, the BFOQ provision, I think, is a good example of how Title VII structurally acknowledges that there will be some permissible sex distinctions. I also find that it's funny, people don't always remember that we have a BFOQ for sex, and likewise, to the extent that people do know that we have a BFOQ, the bona fide occupational qualification exemption, sometimes people think that we have one for race, but we don't have one for race, and we do have one for sex. So the bona fide occupational qualification says that in some situations, and they are limited, you are permitted to hire someone based on their sex. You can also do that for religion and national origin. We don't do that for race. For hiring for race, it's an absolute prohibition. Motivated in whole or in part, if you take an action based on race, you're out of luck in the Title VII context. But structurally, Congress decided no, for sex, there are going to be some things that we're going to deem that permissible. You also see some structural distinctions between race and sex in that we have specific amendments to Title VII with the Pregnancy Discrimination Act acknowledging some female-centric definitions of sex, explicitly that sex discrimination can include pregnancy discrimination. And then separate from Title VII, you also see that we have the Pregnant Workers Fairness Act recently passed with specific accommodation of pregnancy. You don't have similar structures like that for men. So across the board, yes, sometimes the sexes are completely equal, but you don't structurally have a demand that there's no acknowledgement whatsoever that there are distinctions between the sexes.
Professor Coleman?
Yeah, I'm not an expert in Title VII, to be clear. I think I'm here in my Title IX role probably, but I do want to say that I, of course, agree with Andrea that there are real sex differences, immutable, pervasive, et cetera, and that they have functional effects that can have implications in all sorts of areas, including in employment, including in sports, but throughout our life, and that's what it means that they're pervasive. The default since the 1970s in law has been that we are to presume sex neutrality unless we have a really good reason and supported by excellent evidence that the sex differences are real and have functional implications that justify an exception. What I've argued in my work recently is that neutrality is the equivalent of erasure, especially when the burden is so heavy on someone who would want to use sex differences as a reasonable tool to better some kind of a situation or to empower people. And so I've tried to argue in my work, and I'll make the point here, that neutrality, just like erasure, or like erasure being sex blindness in law and policy, right? That by default presumes that sex differences are bad, or that seeing sex differences in law and policy is a bad thing. It's a rebuttable presumption, but again, the evidentiary burden to rebut it is high, which is why BFOQ has been interpreted over the years as being such a narrow exception, even though structurally, as a formal matter, it recognizes the truth of some sex differences. It's been a huge obstacle, and as a result, most law is sex neutral, and we don't feel comfortable using sex as a tool to make a difference when it would be reasonable to do so, when that's the best tool, for example. For me, if you step out of seeing sex only through the prism of sex discrimination law, only through the prism of equality, then you see that it is sometimes good, right? Sometimes it's bad, but often it's just a neutral. And in those circumstances, I don't think we should take it off the table, again, as a tool to solve social problems, but also just to make a difference when that would be, again, the best approach.
So what do you think, just following up with both of you on this question of when, sex neutrality versus sex consciousness, and whether the laws should be sex blind like we want them to be colorblind. What is sort of the test for when we apply our anti-discrimination regime in a way that takes sex into account? I mean, is biology the only time, and does it have to be something that's strictly linked to biology, or that's sort of a cultural byproduct of biology? I mean, in the workplace, for example, Title VII, it says, you can't discriminate on the basis of race, sex, various categories. It's all in one sentence in the statute. It doesn't make distinctions within the statute about how those different groups are to be considered. But of course, the way courts have typically applied Title VII is to say that employers can't treat similarly situated individuals differently or disparately. But of course, men and women aren't similarly situated when it comes to biology, and so that's the reason that, for example, employers can have separate bathrooms for men and women, but not for blacks and whites, right? So what are some other examples of how that plays out at work, or when the law might allow employers to segregate, for lack of a better word, or just treat men and women differently?
Yeah, I think biology drives a lot of it. I think what's really important to understand why we have had sex-specific facilities is that, right, most people focus only on A1. Across the board, most people don't bother to read Title VII, and this is true whenever you read an extensive amount of cases looking at how people have interpreted the different provisions. Everyone focuses on A1, which of course is the terms, conditions, and privileges of employment provision, but there's A2 as well, and A2 says it's unlawful to limit, segregate, or classify an employer's employees, and then it goes on to say, in a way that would, quote, deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee, right? So it doesn't have a blanket bar on limiting, segregating, and classifying employees in a manner that is based on sex. And that's because, and that's where I think you see then the distinctions about how A, the courts, and B, the regulators, namely the EEOC, have handled this. For race, you see the EEOC immediately jumping in and saying absolutely not, no race segregated facilities, understandably, and rightly so, because to have segregated bathrooms based on color or race would adversely affect someone's status as an employee. It carried deep social weight, what was happening there. But that same thing wasn't true for women and men, and as a result, you see the exact opposite for the regulator there. The EEOC jumps in and says, actually, if you don't provide a sex-specific facility for women, that's discrimination. So that biological reality, that context, I think, drives the difference there. And the law is structurally set up to do so. But there's, not only bathrooms, right? Women in the workplace, everyone focuses, I think, on the bathroom issue. But there are many, many people who work in dirty jobs, hard jobs, blue-collar jobs, and they sleep on the job, they shower on the job. They have a host of sex-specific facilities where you would have a lot of very biologically driven needs for separate spaces for the sexes.
So I would just add, I'm agree with everything Andrea said. Again, it's really, it's clear cut. But I would just add that that separate sex facilities, as Andrea said, carry a lot of social weight. But the biology, we always think that the biology is lingering behind that social weight. And I think that it's important when we talk about the justifications for those spaces, especially in litigation or in lawmaking, that we recognize that when we say that they're justified by privacy and safety concerns, that these are not just empirical claims about violations of safety or violations of privacy, that they're actually sort of adaptive behavioral reactions, right? And when I say adaptive, they're universal, and they are true across time, and that signals to us that that where there are functional differences in, for example, physical strength, power, endurance that might justify BFOQs in employment or sex discrimination, distinction, sex consciousness in sports. In the context of separate sex facilities, it's more complicated. There's a first level, which is that social customary level. But if you see that customary level is pretty universal, is pretty timeless, then you have to ask yourself, well, what's the basis for it, right? And the basis for it is largely that it's adaptive, right? Women and girls feel, if they're empowered to do so, want to separate themselves, to relieve themselves, and for grooming. And they're concerned about assault. And it's not because of the numbers of assaults that might happen, so that if you disprove that it's a reasonable, that there's a reasonable assault, a claim for being worried about assault, there's still that sense, or that truth, I should say, and it's increasingly empirically based, that this is an adaptive reaction, and we should question whether, when we challenge the legitimacy of that adaptive reaction, we're not doing harm to women and girls through that action.
Okay, I want to pivot a little bit to the education context and bring Professor Sanga into this conversation. Are colleges, professional schools, and employers required to be sex blind? If not, can and should they be explicitly sex conscious when it comes to admissions and various other things?
So are they required? No. I think that's a pretty clear statement. We even saw it in the SSFA oral arguments. But whether they should, I think, is a more complicated question. Of course, I come at this in more of an empirical angle, but I think this idea of sex blindness as well as consciousness, like there are features of both that I would like to sort of resist, if you will. And let me give you an example from my home institution. The first woman to be admitted to Yale Law School was in 1885. Her name was Alice Blake, and it was a mistake. She had applied with just her initials. I don't know if this is sex blindness, but she had applied with just her initials, and of course they didn't know until it was too late. By the time she shows up, it's too late to rescind the offer. Yale learns its lesson and doesn't admit another woman for 35 years. Fast forward 150 years, and now we find a majority of enrolled 1Ls, 2Ls, 3Ls are women. It's over 50%. Almost half of faculty are women. More than 40% of deans are women. And so a sex-blind crowd perhaps might say, well, this is just law school is becoming increasingly sex-blind. I don't think that's quite right. Whereas in a sex-conscious crowd, or at least some of them might say something like, well, the fact that it's only 42% of women are deans, that's cause for concern. I also don't think that's quite right either. Instead, I would appeal to, for example, the work of Claudia Goldin, recent Nobel laureate in economics, and she's shown pretty convincingly that, of course, in the 60s and early 70s, we have some major medical innovations with with contraception, and especially the pill. And what this is achieving is a kind of fundamental change in the way that women invested in their own education in the workplace, from, for example, in the labor force, this intermittent participation in which women would sort of enter and exit without really building up human capital. Same goes for making these huge investments in their own human capital with law school. And from there into something more about this long-term strategic vision, which is to say, innovations, and the pill is just one example, but these are innovations which put women on an equal footing to be able to plan their futures and careers on the same terms as men. So this is just to say that I think the idea that, sex blindness is going to get us anywhere, I think, I oscillate between whether this is a naive thought or a lazy thought, but either way, it's not historically true, because the only thing that, there's these huge innovations in medicine, in social mores, in the law, Eisenstadt, so on and so forth. This is what is enabling people to, maybe in the best case, take on a sex-blind kind of position. Maybe the last example I'll give is one from a student of mine. I won't out who it is, but basically this is from a few years ago, and she was telling me about her summer job. And she had gotten this extraordinary, she's one of my brightest students, most hardworking, this extraordinary position, and let's just say in the pinnacle of the legal profession. And then she comes back from the summer kind of dejected, realizing that, she looks around and she quickly realizes that, there's this pervasive rejection of family. And, apparently, you get 2 to 6 weeks off for family leave. And God help you if you take the full 6 weeks, because the partners might question your commitment. And it is funny, but also funny, in a horrifying way, if the legal profession is going to hold itself out to be on the vanguard of promoting justice and equality and the rule of law and building a good civil society, well then it can't just wait for states or the feds to do something with child care and so on and so forth. It has to be actually promoting these ideals, which is just to bring us back to whether blindness or consciousness is going to get us there. I think the better frame, perhaps for the law as well, is equal protection, but certainly for the value would be equality of opportunity in building those kinds of structures, putting those structures in place so that people don't have to choose between having a second child and getting promoted to partner.
So, I mean, what should the goal be of law schools, even universities generally at the undergraduate level, employers? What, as a policy matter, should be the goal with respect to representation of women? Should we aspire to proportional representation, in your view, and make whatever accommodations and develop policies that will encourage that? Or, I mean, we know that at an undergraduate level, women, young women are better prepared for college and applying to college in much larger numbers than males, and that without sort of affirmative action for men at the undergraduate level, most colleges would be over 60% female. And, you can tell the few that don't use affirmative action for males because they they're skewed that way. Providence College is one, Boston University is one, University of Charleston, I think. They jump out at you. So what do you think should be the goal in higher ed and professional schools in the workplace? Is our goal proportional representation, or is it different in each context? What do you think, Professor Snago?
Yeah, I think that the goal is not proportional. That is by itself not an impressive goal to have, because that you can cheat. You can get there pretty easily by, with quotas and whatnot, and which is to say that is too, but at the same time, these are not metrics we should just throw away and say, the fact that it's 60-40, we should make nothing of that fact. No, this is a good piece of information to have. Instead, the goal should be to continuously, sort of ruthlessly seek out any, structural barriers, things that are preventing, like why aren't men applying to colleges? What's going on in high school? What's going on before that? Is to find any kind of structural reasons or barriers that are preventing, that are not creating a level playing field, that are preventing people from, let me put it this way, I think, the goal should be, and I hope we can all agree, human flourishing, right? Not hitting some number, right? So this is kind of putting it backwards. The numbers will help us see how well we're doing, but if we're unable to interpret why it's 60-40, there are good reasons to be 60-40 and bad reasons to be 60-40 as well. So I think the goal should be, just to I'll beat this drum all my life, is equality of opportunity, and doing it in a really sophisticated, careful way, which will require potentially, huge structural investments, whether it's in childcare or in paid leave and so on and so forth.
Can I jump in here? Yeah, I'm really heartened to hear you say that, because I think that that's not necessarily the message that you sometimes hear from some on the left or left of center. It is much more that equal outcomes, equity, right, is and should be the goal for civil rights. And I think a lot of conservatives don't really talk about, okay, what is our goal? What's the answer to that? I think the answer has to be that as conservative, the goal is individual rights and individual equality, which is consistent with the concept of individual flourishing. And sometimes that will result in proportional representation to the qualified labor pool, and maybe sometimes proportionate representation to the general public, but sometimes it won't. And provided people are being treated as individuals and they are not facing structural barriers or illegal discrimination, then how it sorts out, right? There are good and bad reasons why you may have 60-40, like you said. But you see, in the DEI space, which I also talk about quite a bit, you see a number of large companies saying, well, I want to make sure that we have 50-50 percentages in terms of our executives. Is that a good idea? I would say no. Is it an easier idea to achieve lawfully than some of the race-based goals? Sometimes, because we have so much higher general representation in the qualified labor pool. But, should we be demanding that women act like men, and the solve for them to be able to advance into the highest pinnacle means that they use all of those technological or medical advances and choose not to have children or freeze their eggs or don't ever have children, period. And that's how they advance at the same pace and rate. I don't think that that's necessarily what we should be advocating for. For example, lots of people focus on occupational segregation. I think it's a very worthy concern when occupational segregation is resulting because of illegal discrimination. But if you have some occupational segregation that's resulting simply because, on average, not as many women want to be trash collectors, which, again, I'm not trying to denigrate. It is a noble job to help, our society breaks down. And believe me, I've been to Rome on a hot summer day. Nobody picks up the trash, and it's a disaster. But just on average, a lot of women don't want to do that dirty, hard job. And on average, not as many men want to be nurses. Also a deeply important job. Some, on average, sex differences likely will result, and if you have a regulator or others trying to ensure that you always are going to have 50% everything, I think you're going to have problems.
Can I add just one sort of
Yeah, of course.
nuance to that? And that is, or to the thing I just said, and that is, I think there are settings in which this this proportionality goal is just, right? And then there's settings in which maybe it's misguided or at least not promoting individual liberties and flourishing. And so, for example, if the next cabinet or the United States Congress is 60-40 even, I'm not sure I'm pleased with that result. I'm not sure I care how we arrived at that result. These are things that we can choose socially together. And certainly 90-10, I would say, is a 5-alarm fire. At the same time, now wind back the pipeline one step. The same goes for the bench. And one step more, maybe the same goes for the legal profession. And one step even more, if we're thinking about this pipeline, now maybe we need to think more carefully in law schools. If these are the jump, sort of the springboards to the highest echelons of elite leadership in not just private industry, but more importantly in the public, then maybe proportionality becomes a different kind of, the rationale for that would then change if we're sufficiently forward-looking and if in fact it's having that result in the long run.
I want to bring in the constitutional lawyers and maybe broaden out a bit and talk about the Equal Protection Clause. If we agree, as I think we all do, that sex is based on biology and men and women are different, do you agree that the current intermediate scrutiny constitutional standard makes sense as a framework for judging when sex-based laws violate the Constitution? We can start with you, Erin.
Sure. Thanks so much, Jennifer. So I love what we've been hearing, especially this idea of human flourishing and what that looks like for both women and men in the workforce and in the legal profession, and love the challenge to the legal profession to make good on providing equal opportunity to women. So to think about the Equal Protection Clause and whether that sort of accounts for these biological differences, we have to, of course, know what that test is, and that is substantially related to an important governmental objective. So I think where the rubber really meets the road is how that test is applied. Justice Scalia, in his dissent in Virginia Military Institute, noted that he didn't really have a problem with the tiers of scrutiny. You know, we can note, as many of us do, that the tiers of scrutiny are not in the Constitution, but there does have to be some framework for which to judge constitutional standards. And at least from Justice Scalia's standpoint, he wasn't so much upset about intermediate scrutiny as how it was applied. And if we take the principles that this panel has been talking about, that sex is immutable, that it's biological, that there are often, or at least sometimes, good reasons for making distinctions based on sex, then that test should account for those differences that, as Justice Ginsburg said, are not cause for consternation, but cause for celebration. And so when you think about that, if you look at the VMI opinion, Justice Ginsburg uses the phrase exceedingly pervasive justification. Now, I think many of us on the panel here, I certainly would have an issue if that's how the intermediate scrutiny inquiry proceeded. If we needed an exceedingly persuasive justification, then maybe we wouldn't have things like girls' sports teams. Maybe we wouldn't have things like private spaces for showering or sleeping in the equal EEOC context. And so I think that whatever your standard is, if we're assuming that it's intermediate scrutiny, that there needs to be enough play in the joints, that important interests are states' protection of girls in sports, are promoting equal opportunity for women in education, in the sports field, as well as in job opportunities, and that sometimes these sex distinctions are relevant and important. So I think that's really where the rubber meets the road. How is that test applied?
General Sauer?
Thanks, and I'll begin with the standard government disclaimer too, even though I'm not currently a government attorney. I have been one in the past, I may be one in the future. I'm here speaking only in my individual capacity, not on behalf of any client or any future or past government official. I am drawing, however, on my experience in having the honor of representing the legislative leaders of Arizona in defending their Save Women's Sports Act in the Ninth Circuit and now in the U.S. Supreme Court. There's 3 petitions pending, one from Idaho, one from West Virginia, and ours from Arizona, and I think those petitions will be interesting to watch this term. I don't have too much to add to what Aaron said, which I thought was very, very insightful. I mean, obviously, the question of, should there be intermediate scrutiny versus strict scrutiny when it comes to race versus sex, certainly I think everyone can agree that the Equal Protection Clause reflects our judgment as a society that race is always, or virtually always, irrelevant when it comes to government action. But I think everyone also agrees that sex is not always irrelevant when it comes to government action. And as Aaron pointed out, there's a passage in United States versus Virginia in Justice Ginsburg's opinion that kind of makes that point very powerfully and talks about these differences are the cause for celebration. Interestingly, all 3 of those petitions, I believe, quote that passage very prominently in the Save Women's Sports context. So, and I do think that regardless of what one thinks of tiers of scrutiny generally or tiers of scrutiny as applied in this particular context, a lot of times where the rubber hits the road is how is that being applied? And if you want a detailed exposition of our views on that, you can see our petition in Peterson against Doe. But in other words, there is going to be ongoing litigation, ongoing battles about those issues, specifically in the transgender context, but not only there. And a lot of the differences you see circuit split after circuit split in this context, a lot of the difference is really not what is the standard, but how are we applying that standard. And that brings it, in certain cases, one thing we emphasize in our petition, factual disputes, expert battles, and how do you defer to legislative fact findings and questions of that nature.
Professor Coleman?
I just wanted to add that I agree completely with Aaron that that the addition to the gloss on the intermediate scrutiny standard, that is the exceedingly persuasive justification test, has caused problems in application. It's essentially designed to jack up scrutiny to quasi-strict scrutiny, or even to equate it with strict scrutiny, especially when it's coupled or it borrows the necessary prong of the tailoring test in addition. What animates that move, and what has animated that move over the years, has been both a political desire to get scrutiny for sex up to strict scrutiny, right, to match it to race, but also a sense from some of the same advocates, but not always the same advocates, that over time in the 70s, 80s, 90s, when the exceedingly persuasive justification gloss was added, we didn't have the same, or we didn't have the basis in science and empirical studies to provide the evidentiary basis or evidentiary foundation for the arguments we made about real sex differences. I don't say we because I was probably a child for some of that, but just that were made, right? And I wanted to just a nod to Ted Olson, who was a good friend of our families, Ted and Barbara. My last conversation with Ted was 2 years ago when I interviewed him for my book about his argument in BMI. He represented Virginia in the United States versus Virginia. And in that interview, he expressed frustration about the fact that he couldn't get any traction with the court with his evidence about real sex differences. And in that case, he was arguing that there are real sex differences in essentially neurological development that that have an effect in the educational environment, right? And that might appropriately be taken into account there. Well, in 1996, there just wasn't he didn't have the data that we have today that documents those neurological differences, and it does exist today, right? And so when you match up the exceedingly persuasive justification gloss on an already intermediate level of scrutiny, all of this assuming that real sex differences are just myth and stereotype, right? You're familiar with that argument, that they're just myth and stereotype. It's sort of, it doesn't jive with the evidentiary basis we have today to support claims about real sex differences. And to show, and there was a reference to RBG and BMI here, and the rationale that we might celebrate sex, but not only celebrate sex, also, you can use it to remedy past discrimination, to celebrate, but also to empower the nation's people. Right, that's the third rationale that Ginsburg provides in her majority opinion for why you might, or how you might meet this exceedingly persuasive justification test, or even if you take out exceedingly persuasive justification, the intermediate scrutiny test standing alone. And education is all about empowering the nation's people. I mean, of course, it's an individual interest as well, right? But the reason we support public education, the reason we have, we indirectly support private education is because there's a societal interest in educated people. And so I agree with Sarath that proportional representation isn't necessarily always a valuable goal unto itself when there isn't proportionality, right? When it doesn't happen naturally. We should be asking why. And if, for example, we see, as we do today, tons of empirical evidence, overwhelming empirical evidence, the boys and men, or boys, let's start with boys. Boys are struggling in elementary school, boys are struggling in junior high school, boys are struggling in high school, and that's why we're seeing the 60-40, right, in places that don't have sex-conscious admissions. We need to go back and ask why, as Sarath said, and maybe sometimes we need to use sex-conscious tools to address that, and I would say see Ted Olson.
I want to talk a little bit about how we define sex discrimination as opposed to just sex. And obviously this is an issue that came to the fore in the Bostock case, where Justice Gorsuch essentially said that we're to apply a but-for test, and that any time an adverse employment decision would have been different but for the sex of the employee, there is illegal sex discrimination. And the example he used in that opinion, I forget what the teams were, but he basically said something to the effect of, if an employer fires females for being Yankees, fires Yankees fans who are female, but not men who are Yankees fans, then that's sex discrimination. And that's how he sort of reasoned his way into if an employer fires a male who presents as a woman or who identifies as a woman, but not a woman who identifies as a woman, then to use that sports analogy, that's a form of disparate treatment under Title VII. But the but-for test, even if you accept Bostock on its face, I think is very difficult to apply outside hiring and firing decisions and outside the employment context. But unfortunately, I think several courts have just taken Bostock and applied it hook, line, and sinker to these other contexts without parsing what that really means. And I'm just wondering, Aaron, if you want to talk a little bit about what applying that but-for test, literally to other contexts would look like, and why it's problematic.
Sure. So I think Title IX is the most obvious example, and it's not just plaintiffs who wish Title IX included gender identity, but it's also administrations. So the justification for the Biden administration's revision of Title IX to include gender identity is their determination that Bostock is controlling and there's no difference or distinction between Title IX and Title VII. I think that's wrong on a number of fronts. The language itself is different. But if we take Bostock at its face value, and anytime you have a but-for relationship to sex, that would mean under Title IX, we can't have sex differentiated sports. We can't have sex differentiated private spaces precisely because you would be looking at sex in order to make those distinctions. And we know from the text of Title IX that that's not what Congress intended. If you look, there are specific exemptions for dorm rooms, for private spaces, and in the very first regulations implementing Title IX, regulations make clear that that also extends to things like locker rooms and sports. And one sort of interesting wrinkle here is if you're going to take Bostock at face value, that it does apply to sports. But the administration's Title IX rule sort of carves out sports, and they say they're going to issue a sports alone rule perhaps before the end of the term. So I guess one question is, how can that be? Is that internally consistent? And if it's not, does that mean Bostock doesn't fit within Title IX?
And I just want to ask you as an administrative law expert, what is the role of, bureaucrats at the Department of Education in A, defining terms in the statute such as sex, but B, applying Supreme Court jurisprudence and tests to expand, define, make policy?
Sure. So I just have to say thank goodness for Loper Bright. And in that decision, of course, we have the Supreme Court saying clearly that what is controlling for purposes of regulations and statutory interpretation is the text of the statute that Congress enacted, not what an agency thinks is a permissible view. That is a huge shift. It will matter in cases like the Title IX cases that may wind up at the Supreme Court. And I think it just clarifies, this case clarifies that the congressional text is what is enacted, it's what Congress voted on, it's what the president signed, and regulators, bureaucrats, of course, have to implement that text, but they have to arrive at the best meaning, otherwise courts will tell them what the best meaning is.
I'd also say that it's really important to, again, not be too selective with what you're reading from Bostock, even in the employment space, like not even jumping to the next context. Everyone focuses on the fact that this is now expanded to transgender status. But again, Justice Gorsuch has a whole line when he talks about the fact that this is not outside of the firing context yet. He's only talking about hiring and firing an individual, and he goes on very, very carefully to talk about what does discrimination mean, right? This is a fundamental question. And we talked about this a little bit at the beginning, right? You've got the fact that when you're talking about A2, limit, segregate, and classify, that you have to have something that is depriving or tending to deprive someone of employment opportunities or otherwise adversely affecting their status. And then separate from the actual text of Title VII, you have extensive Supreme Court case law, which again you see in Bostock, and then you see incorporated in Muldrow, which is the latest major Supreme Court case in the employment context. That also talking about A1, the terms, conditions, and privileges there, and they reiterate this language that Gorsuch says, that's the term discriminate against refers to distinctions or differences in treatment that injure protected individuals. So yes, he says firing employees because of a statutorily protected trait surely counts, but whether other policies and practices might or might not qualify as unlawful discrimination or find justifications under other provisions of Title VII are questions for future cases, not these. So the idea that you're going to take the prohibition against hiring or firing based on transgender status and then immediately port that into any other context that involves a distinction based on biological reality, much less jump into a whole other statute, you are completely extending it, and you're really very selectively applying Bostock. It simply is not warranted. I'm quite passionate about this because the EEOC has completely ignored those words and jumped immediately into this idea that now there is the abolition of sex-specific spaces at work. I dissented against that. I did not vote for that, and I think we were completely overextending Bostock in doing so. But I would encourage people that before you even jump to the statutory differences outside of Title VII, don't ignore the fact that you have case after case after case in the Supreme Court, making very clear that discrimination does not extend to every single distinction that one might make. There is a whole set of lawful distinctions that people can make that are not necessarily injuring people. And I think if that was too long, didn't read, I think the takeaway is biology is not bigotry, and we really need to resist.
General Sauer, did you want to jump in on that?
I don't have too much to add. I would observe that there are two closely related circuit splits in the transgender rights litigation context. One is whether or not transgender individuals are part of a discrete or insular minority that are subject to a quasi-suspect class that's protected by intermediate scrutiny on that basis. The other argument is that they're protected by intermediate scrutiny because sex discrimination inherently is a form, or discrimination against people who are transgender is inherently a form of sex discrimination. And so they're fairly deep and look like persistent circuit splits on both of those questions. The opinions that tend to side with the plaintiffs, so to speak, on that do tend to adopt both rationales. And the litigants are certainly arguing both of them. They want to get to intermediate scrutiny, obviously, and so the argument is made, well, we're in intermediate scrutiny because if you're discriminating on the basis of transgender status, you're automatically discriminating on the basis of sex, see Bostock, or in the alternative, transgender status is a quasi-suspect class. And I think the reason you see that is I think most court observers would think the court's going to be reluctant to recognize new suspect classes. So I think you see that argument being placed front and center, and you do see persistent circuit splits on both of those issues.
So now that we've sort of pivoted towards women's sports and also some of the transgender issues, I want to ask Professor Coleman a couple of things. First of all, I'm curious as to why you think the women's sports issue has become kind of the fault line in the culture wars, for lack of a better expression. But I also want to ask you, playing off of what Aaron said about Loper-Bright, what you think a more restrictive administrative law regime would look like for women's sports generally, and how Loper-Bright could be applied to Title IX. I know you have some very strong views about that, so I'd like you to share them.
First, I'll say that was the most compound question I've ever heard.
Sorry.
It was fabulous. It's like, give me your oath, right? Just two quick notes. One is that with respect to a broad reading of Bostock, of course, that's what litigators do, right? And so trans rights advocates have taken Bostock and ignored the piece of the opinion that says we're not talking about exceptions to general non-discrimination rules, we're just talking about rules generally, and they've tried to apply that general reasoning even to exceptional contexts like sports, like bathrooms and other things. I just want to note that in the sports world, in the sports regulatory world, we're really concerned, of course, about a broad reading of Bostock, and we're not thinking just about the competition tomorrow or next month. We're actually focused on Los Angeles 2028. That's in California. California has a general non-discrimination law that is their accommodation statute that is essentially a state version of the Equality Act that didn't pass Congress, or that hasn't passed Congress. And it's been interpreted by the ACLU and advocates for gender diverse people as barring, and then see Bostock, right? This is what they say, as barring any kind of distinctions on the basis of sex, right? And so if you are the IOC, if you're the international federations, if you're the United States Olympic and Paralympic Committee, where it is assumed, right, not only that you can have separate sex sport and eligibility standards for girls and women's sports, or for women's sports that are based on sex, not only that they're permitted, that they're required, and you have a commitment to one-for-one sex equality, equal quota spots. This is what the IOC said for Paris, right? Equal quota spots for males as for females in Paris, and then the same commitment is being made for Los Angeles. How do you square that with an interpretation of California's public accommodation statute that is essentially the Equality Act that would disallow all of those things? So there's a lot of concern in the international Olympic movement over that issue. On the Loper-Bright piece, and then we'll go into the culture wars. On the Loper-Bright piece, I would say whatever your view is of Loper-Bright in terms of administrative law generally, it has significantly weakened Title IX. There's no question about that, right? Title IX was on I would say on quicksand before, or it was a house of cards before Loper-Bright, because the Title IX, the statute, says absolutely nothing about sports. And the amendment that helped, that is supposedly the hook for the regulation that is what we think of as Title IX sports, merely says that Congress should make reasonable regulations for university sports. It says nothing about school sport. It says nothing about school sports. It says nothing about separate sex sports. That's the statutory text on which this whole edifice that we think of as girls and women's sports in the United States rests. As an aside, the Ted Stevens Olympic and Paralympic Sports Act says nothing about separate sex sports. So all of what we think of as this, we have no sound foundation for this movement, for this institution that I hope we know and love, right? And increasingly so. It's increasingly an important institution, commercially and otherwise. And so Loper-Bright, once that light is shined, right, the Loper-Bright light is shined on this regulatory scheme, it's clear that it doesn't stand without substantial support. And that leads me to answering your last question, which is why girls and women's sports have been so provocative and central in the culture wars. I always have three reasons. I always have three explanations for this, because I think there are three different groups of people who've been provoked by the challenge from the transgender rights movement. And the challenges to the central rationale for the institution, right? That is sex differences between males and females. And so claiming that sex differences are only myth and stereotype, claiming that there are no real sex differences, claiming that sex isn't binary, or claiming that even if all of that is true, it's still not right as a policy matter to take it into account. It provokes three different groups of people, right? It provokes those of us like me who actually deeply care about girls and women's sport for the individual cultural and political value it produces. It provokes those who don't care very much or even think about girls and women's sport very much or don't care about it very much, but who do care about sex a lot. Right, and this is back to are we ready to talk about sex? Who do care about sex a lot, and who see clearly through sports that it's not just a bad thing. Sometimes it's worth celebrating, right? It's good, it's bad, it's neutral. Here, it's good. And I'm going to say RBG and VMI. And then, of course, there are lots of people who have just cared about it as an election issue, and I don't want to ignore that. I don't want to skirt that. That's just a truth. What I hope, and this is a pitch, right, is that everyone who's been interested for one reason or another helps us to get the institution on sound legal ground going forward. And that's a reference back to the problem that Loper-Bright has created for Title IX, and it's a reference to ongoing litigation around the states where sometimes lawyers for states that have supported Save Women and Girls in Sports Acts don't do the work, the groundwork that's necessary to lay the evidentiary foundation, the scientific and policy foundation for the institution and for their statutes. And then of course the Ted Stevens Olympic and Amateur Sports Act. Again, we're worried about this in the international context. In part, we're worried because there is no statutory foundation, and so what you have is California's public accommodation statute standing alone, and it's unclear if we don't do something to shore up the non-school side of competitive sports that we're not going to have a really big problem in California in 2028.
Yeah, in the sports context, there are a bunch of cases winding their way through the courts, and in a variety of postures, but basically you see people challenging state laws that aim to protect women's sports, which is what John has been involved with. And then you see, people on the right challenging the Biden administration's regulations, which purport to apply Bostock in a way that, in my view, not only allows trans-identified males into women's sports, but will ultimately, if accepted, prohibit single-sex teams to begin with. Erin, you're working on a subset of those cases, and I wonder if you could just talk about what you think the prospect of those cases are in the courts, but also what you think the change in administration will mean for that line of argument.
Sure. Yeah. So I think you're right that there's sort of three buckets of litigation that could be impacted by the election. The first bucket is the Arizona case that John referenced. There's BPJ out of West Virginia, Hecox out of Idaho. And in those cases, the United States has said that state laws protecting women's sports and differentiating between boys and girls teams are unconstitutional. So those petitions are pending before the Supreme Court. I would guess, you can only speculate, but I would guess that perhaps the administration might change a view on that, but
Might.
so I think well, anyway, I would expect them to do so, but I obviously have no say in that. So those that bucket of cases, that bucket of cases is being challenged by private plaintiffs. So we might have the administration come in on the other side, but the conflict will still exist. The other bucket of cases are cases, the Title IX cases, and these cases are being challenged, challenges to the Biden administration's Title IX rules. We'll see what the Trump administration does with those rules. It has a variety of options. It could say that it's not going to enforce those rules while it revisits them. It could continue to defend those rules while it revisits them. You could have blue states seeking to intervene in that litigation to continue adversity between the parties if the Trump administration switches positions. So we don't know what precisely that will look like. The cases could be stayed as the Trump administration works through a rule. They could continue, especially if you have interveners, but that's to be determined. As I mentioned before, we might also have a sort of midnight sports rule that will probably be challenged. And then the last thing I wanted to mention is just this Loper-Bright issue, because it is a double-edged sword, because of course the Loper-Bright the Chevron decision featured prominently in the Biden administration's defense of including gender identity within the definition of sex. And under Chevron, the federal courts would have been required to defer to that last-in-time interpretation by the administration. And I'm not sure that I disagree, but I would point out that there are a number, I think, of at least textual clues that we can get from Title IX that it does protect separate sports teams. If you look at the contemporaneous regulations, those supported interpretation that would include sex differentiation. In addition, if you look at how Congress has amended the statute, past those regulations, you can make the argument that that is Congress accepting that interpretation of Title IX. So all hope is definitely not lost without Loper-Bright, and in some cases it's definitely improved.
Although I think some people would say, even if you can interpret the statute to say that separate sex teams are allowed, maybe we should amend the statute and go further and say equal separate sex teams are required. Because if schools are put in a position where maybe they feel that in order to, whether it's to accommodate LGBTQ activists or to comply with the state law, that the only thing they can do then is offer a single-sex team per sport, that would obviously disadvantage women, right? So I think there's a movement, to some extent, to basically codify the current athletic regulation, which requires equality of athletic opportunities, And because of biology in the sports text, that does essentially mean same number of teams for men and for women. John, I wonder if would you talk a little bit about the Arizona case and the equal protection challenges that are being brought against the state laws that protect women's sports, the laws that you're defending?
Sure, just generally, there's a series, in almost all these cases, I believe they're asserting both equal protection and Title IX claims, and there's an interesting kind of variation in the way the courts have gone, like the Fourth Circuit in the West Virginia case actually didn't quite decide the equal protection claim. They vacated a victory for the plaintiffs in that case, or the defendants in that case, and sent it back for further consideration, whereas they did decide on the basis of the Title IX claim is the opposite in the Ninth Circuit in our case, where they decided on equal protection grounds and said, therefore, we don't need to reach the Title IX issue. Our district court had ruled on both grounds and found for the plaintiffs on both grounds. So, and that one of the petitions therefore says, I can't remember if it's Idaho or West Virginia, hey, maybe the court ought to consolidate these because they're coming at it from different angles. So that is, again, I think those are interesting petitions to watch this term.
I think while we're on sports, we'll stay on this for a minute and the transgender issues there. In the court of public opinion, a lot of people focus on the fairness aspect of allowing male-bodied athletes into women's sports and argue that it's not fair because of biological realities, that, boys are bigger, faster, stronger on average. But really, I think the stronger legal argument, because Title IX is not a fairness statute, it's an equality statute. The stronger legal argument really focuses on the loss of opportunities for women when males roster on a women's team with limited roster positions, and then by definition push girls in high school down to the JV team, or prevent a woman from getting a college opportunity to play, or even if they're on a team at a college, they end up they would deny women playing time, right? Because even as a fairness matter, if it doesn't make that team so strong that it's unbeatable to have one male-bodied athlete on the team, it does mean that the girl at the end of the bench isn't getting off the bench and having an opportunity to play. And I wonder if any of the panelists could talk about just the fairness argument versus the equal opportunity argument, and which is likely to prevail or not.
So I'll jump in here just quickly. So I focus on this mostly in the international arena, but the arguments and concepts are the same. I think fairness is, of course, always a goal in sports. What makes a competition fair is that everybody's playing by the rules. And if we think, if the rules say that the female category, that's how we describe it in the elite sports space, but girls and women's sport exists as a space for females to compete only against each other. The idea is to exclude male advantage, and the rules provide for that, right? Then it's unfair to include male advantage into the field. But it's not nearly enough to focus on fairness, either legally or conceptually, because of course the rules can be amended to make accommodations for male advantage. All of the rules that people talk about in this debate that are designed to, and the expression is balance, fairness, and inclusion, are arguments for revising the rules to make it fair to include certain XY athletes, right? And so focusing only there is a problem, again, both conceptually and I agree with you, Jennifer, legally, because once the rules are changed, then everybody, of course, is playing by the rules, at least technically, right? It's important to focus on why we have separate sex sport, why the rules are the way they are before they're changed. And that requires a focus on equality, right? We have separate sex sport because we've committed, given the biological sex differences in power, strength, and endurance, we've committed, and the commitment, I should say, and the commitment, together with the commitment to sex equality, it's the rationale for the rule, and it should be the basis for eligibility into girls and women's sports. In the international sports space, we are committed to an equal number of spots, and the quotas in finals, on podiums, and in championship positions, right? We're committed to that, and that's the equality commitment. But it's not the only commitment. I want to just add this, that the rationale for separate sex sport and a sex-based eligibility standard is equality-based, but it's also cultural or commercial, right? Girls and women's sports has goals beyond equality for the individual female athletes who might be participating on a given day. In the commercial space, we talk about doubling the value of the enterprise, right? So not only the world's fastest female, or the world's fastest male, I should say, but also the world's fastest female, and that doubles the commercial value of the proposition. In school sports, it's not a commercial goal so much as it is a cultural one, right? We're not just fielding the best men's team, we're also fielding the best women's team for all of the cultural value that produces. And then sports, girls and women's sports does a lot of political good, and we focus on that when we focus on what are our goals, what's the mission for girls and women's sport. And there we're looking at the optics of seeing powerful female athletes competing against each other for a championship. And we see that, like, as I say, the optics, I want you to see the picture in your mind, right? The podium and the female-bodied athletes on the podium, and how different the messaging is when that podium is mixed sex, regardless of who's atop it. And so I think it's really important, obviously always important to focus on fairness, but understanding that what is fair and not can change as a regulatory matter, and that ultimately, in order to defend the proposition that there should be a sex-based eligibility standard for girls and women's sports, we've got to focus on the mission of that institution, and that mission has three components: that equality component, the cultural or commercial component, and the political component.
I think when you talk about the cultural and commercial component of sports, I mean, you could equally apply that to law school admissions or deanships or whatever, right? The argument that some feminists make that it's important for women to see themselves in these roles as dean or on the Supreme Court, what have you. Professor Sanga, I wonder how if you see sports as fundamentally different than law schools in that regard, in terms of the cultural component, or if you look at those through the same lens?
Yeah, it's not something that I think I've really thought deeply about, but just kind of building on a couple things that Professor Coleman said, I think, at least from an relative outsider's perspective, the thing that makes this sort of culture war frame so tedious is that and I'm just as guilty of this as the next guy, is that it sort of elevates sex and gender and so forth as if that was the purpose of sport, right? I imagine many in this room have heard the phrase or the retort that the Sabbath was made for man, not man for the Sabbath. This is, of course, in response to a question as to whether, if following a rule, you should follow the rule if it ends up hindering someone. And the obvious response is that, rules are not sacred. Like, the lines drawn are not sacred. The 1896 people are sacred. Women are sacred. Trans women are sacred. The 1896, speaking of Olympics, the 1896 Olympics had no divisions. It was open competition because there were no women. And the divisions were drawn initially in order to expand opportunities for flourishing through competition. And so I think the moment that it stops, I think it's a different context, because the moment that those divisions or those lines stop promoting these goals, then we were not made for these lines. Now it's time for the lines to adapt, and I don't have the answers. I think Professor Coleman can speak better on this, but whether that means new categories or just new ways of thinking about competition, like, this should all be on the table rather than a blind, let's say, deification of the boundaries and right, I mean, we have all these weight classes, age, ability differentials. So I think these were all just conventions that it's time to adapt.
So I want to make sure we leave time for questions, but I'd like to open it up to any of the panelists who want to elaborate on any of the points that have been made. Anyone? All right, well, and with that, we'll take some questions from the audience, I guess.
It's hard to see, right?
Oh, way in the back, yeah.
Yes, go ahead. Go ahead. I can't see. I can't see, so whoever has the microphone,
hear me?
just ask
Can you hear me?
away.
Hi, Christine Johnson speaking for myself. I want to go back to the distinction that was being made between neutrality, sex neutrality and sex consciousness. And under Title VII, Commissioner Lucas was describing how it is focused on non-discrimination, fill in the list, race, sex, national origin. And in Title VII, there was a requirement to non-discrimination on the basis of religion requires an actual accommodation. So religion, by definition, requires accommodation of religion. It's not just not discriminating against someone on the basis of religion, but also accommodating that religion. Could it be said that also under Title IX that there is an affirmative duty to be sex conscious as opposed to Title VII, and that those two statutes by their terms could be taken differently and in terms of sex neutrality and sex consciousness?
Anyone?
I can't hear what she's saying because of the echo.
Does anyone want to jump in on that?
I am not a Title IX lawyer.
Did you understand what she said? Could you repeat it?
What's that?
Could you repeat what she said because of the echo?
Could you just sort of repeat the question very succinctly, because we couldn't hear that well. I think.
There's an echo in the room, and so it's really hard to discern.
I think I heard it okay. I think the argument was, could you say that just as in Title VII, to discriminate based on religion also means that a failure to accommodate would be to discriminate? Could you do that maneuver in Title IX and say that is that the gist?
Correct. There are times when there's an affirmative duty to accommodate, even under Title VII, but that's based on the definition of religion for Title VII. So there must be a religious consciousness, whereas on the other terms of Title VII, it's sex neutrality, race neutrality. Can it be said that for Title IX, there needs to be a sex consciousness because of the way that statute is structured?
Not knowing Title IX that well, I would just say in general, Congress knows how to write accommodation statutes. So I'm personally always a little hesitant to read into accommodation where we don't have it, right? The PWFA is an accommodation statute. The ADA is an accommodation statute. We allow specific acknowledgement of those protected characteristics there. Even the ADA, when we're talking about age, the discrimination only goes one direction, right? You can't. There's no prohibited discrimination based on, in favor of older people against younger people. So, I don't know about Title IX, but I think Congress knows how to write things, and maybe the solution is just we need a congressional solve there.
Yeah, I mean, I agree with Commissioner Lucas, but I would also say as a political matter, I do think it's interesting that the transgender movement has made its argument for inclusion in women's spaces. They've focused their argument on civil rights and anti-discrimination law. So they've demanded it as a right, as opposed to asking for an accommodation, which I think, as a political matter, they probably would have, I think, received more empathy from the general public if they had crafted their arguments in terms of accommodation. And what I mean by that is, for example, in the sports context, there are lots of ways that teams or communities could accommodate transgender athletes, and even non-transgender male athletes on women's teams. And the example I always give is my daughter plays field hockey at a Division I school, and they have a male practice player on their team. He's an international student. He is a phenomenal field hockey player. And in his country, field hockey is a male sport where it's not in the U.S. for the most part. And so he is accommodated. He comes to the U.S. He can't demand to try out for the team as a right, but the team chooses to accommodate him. He practices with them. The girls would say he makes them stronger players. He's included in the life of the team, the social life of the team. He wears all the gear. He comes to the dinners at the coach's house. He does community service with them. He runs youth clinics with them. He does not go in the locker room. He does not ride the bus. He does not get a minute of playing time. And that's an accommodation that's made for this male student. Theoretically, one could do things like that. Leah Thomas could have been accommodated by, being a part of the women's swim team, but racing with the males. But the transgender community doesn't want to be accommodated. They don't like the language of accommodation because I think they've made a political decision that makes people think of transgenderism as a disability, which they do not want. So they've been unwilling, I think, to compromise, as it were, and so now we have what's essentially a clash of rights between women and men who identify as women. So I don't know if that answers your question, but it does kind of talk about how we might conceptualize things through the language of accommodation versus unfettered right.
Hi. Yeah, you have 3 microphones. I'm up to the left here. I'm Joe Cosby from Washington, D.C. I was listening especially to the discussion about athletics. I heard a lot about competition and what would be fair, what the best way to adjust things or what to do, but I didn't hear anything about, women spaces, right, specifically for women, which is a big part of the debate. I didn't hear anything, apart from fairness, about, for instance, the boxing issue at the Olympics. It wasn't just about fairness, although that was a critical part, but also about whether or not you were putting women into a position or girls in a position where they could get hurt very easily. And I'm wondering, why that wasn't part of the discussion here, and what could you address that?
Well, it's a big topic, right? Sex, gender, and the law. So I think part of the reason I teed up the conversation the way I did is because I think it's important that we situate the transgender debate in the larger context of men and women's equality, because it really is just a subset of some of these issues. Because what the transgender community is asking is for sex blindness and really the erasure of sex categories, which is no different than what some of the feminists were asking for in the 1970s with the Equal Rights Amendment. So the movement to eradicate sex categories and to always treat men and women the same in every circumstance, even when biology is implicated, that's been a push from the left for a long time. The transgender part is the latest iteration, or maybe just the most absurd iteration of that. But yeah, to answer your question about spaces and the women's sports, argument, the same arguments apply to all women's spaces, sororities, prisons, bathrooms, locker rooms. The women's sports issue just sort of has been front and center politically, but the same arguments about whether biology matters and whether women have a right to private spaces when biology is implicated touches all of that. And I will just add quickly before I let other people jump in that the Independent Women's Forum actually developed what we were calling a Women's Bill of Rights. And it's actually been passed into law in 8 states now. And the idea of the Women's Bill of Rights, which perhaps is misnamed, but the twin goal of the Women's Bill of Rights were to do 2 things: to sort of codify in state law the ability of states to have separate spaces for men and women when biology and privacy and safety are implicated. So all those areas, sports, prisons, sororities, whatever. And so basically, the first part of the Women's Bill of Rights was aimed at insulating states from challenges from the left where people sued to say, having, separate prisons for men and women violate the Equal Protection Clause or violate state law. We wanted the states to be able to say, we wanted prisons to be able to respond to transgender inmates who said, I have an unfettered right to be in a women's prison cell with another woman. We wanted them to be able to say, no, the state law, the Women's Bill of Rights, gives us the authority to have separate men's and women's prisons. So that was the first part. And then the second part of it was, the second part of the Women's Bill of Rights was to explicitly define sex-based terms. So sex, woman, female, male, father, mother, for the purposes of state code. So there would be a universal definition of sex-based words across state code, because a lot of states define those terms separately in each part of their statute. Like the adoption code might define mother one way, and an education code might define it another way. Anyway, so the Independent Women's Forum put this out, and it's sort of aimed at addressing all of these issues from the global to the more specific.
I'll also weigh in just to say, this is a broad topic, as Jennifer said. And this, what I'm about to say is not a critique in any way, shape, or form of any of the panelists, but more of the broader movement of talking about these issues. It's easier to talk about sports for men and women and talk about racing or competition or who gets the medal because most people don't want to talk about sex. And I mean like sex, as in physical differences and sexual assault and all of these things. We had a long discussion about Me Too a hot second ago, and suddenly everyone was comfortable talking about the biological realities of sexual assault and sexual harassment. And then the second we get into the culture war issues related to transgender rights and how they implicate women's sex-based rights, it's much simpler for people in the movement or the politicians to talk about something where you don't actually have to talk about sexual assault or genitals or biological realities like pumping or periods, right? Those are messy, uncomfortable things that are deeply personal, and not everybody wants to talk about them, but they have real implications, specifically, primarily for women. I think the UK movement of gender-critical feminists have talked more about that than some in the United States have talked. But there are just, they are real privacy and safety issues that do need to be dealt with and talked about honestly. When you're talking about eliminating sex as something, we're going to acknowledge that the protected characteristic and move to something like gender, right? Whether it's in the employment context or other places, it's going to implicate a whole lot of spaces like domestic violence shelters or rape crisis centers or other, nonprofits for women who are deeply vulnerable, homeless shelters, gyms, spas, locker rooms, childcare facilities, huge swaths of society where we have had safeguarding principles for decades to protect women and children, those are not based on an idea that every male will engage in assault, but the idea that males on average do have higher propensity for crime and sexual assault. And the way we protect women and children is that we have those boundaries and safeguarding. I think it's really important for people to talk about that and to lean into the discomfort, because that's how we protect women and children.
I will also add, quite honestly, that the entire topic of the convention could have been sex, gender, and the law, right? And then with breakout panels or showcase panels on each of these topics. I mean, we haven't even gotten to pronouns and free speech, right? I mean, so there's a lot here, and we welcome your specific questions on any of the topics. That we were just kind of setting the table and giving the big picture for this issue, and so ask away about pronouns or prisons or whatever.
Thank you. Rob Rigrish. I'm an employment litigator from Atlanta. And it's really a two-part question. The first is, should we blame or credit Justice Gorsuch, bless his heart, for amending Title VII with the Bostock decision? That's the first part. And the second part is the solution to this, Congress performing its Article I responsibilities and amending Title VII and Title IX to clean up this mess. Thank you.
So on the amending part, I would say yes, they should, and also the state should, and that's where the Women's Bill of Rights comes in. At the federal level, Debbie Lesko and others, I know there is a federal Women's Bill of Rights that was introduced as a bicameral resolution. But it would be great if it could be passed into law, because it would address all of these things.
And it wouldn't only clarify the lack of clarity that results from the Bostock decision, it would also firm up, and I'm speaking to sports specifically here, would firm up the law in that area that has been, and I agree and disagree with Aaron on this, that has been on fragile ground for a long time anyway, and so it provides an opportunity to clarify all of that if that's what we want to do.
Hi, my name is Devin Watkins. I'm trying to understand the kind of legal test that's being suggested from kind of the point of view of a judge. Now, I understand it differs based on the specific statutes, but I wanted to put forward what I'm hearing from you and seeing if there's more nuance to it or I'm misunderstanding something. What I'm hearing is that, like, adverse discrimination is illegal when it's kind of the but-for cause and caused by sex. But like non-adverse treatment and distinctions based on sex are presumptively lawful when based on biological differences, unless those reasons are pretextual in some way. Is that what's being suggested?
Yeah, I mean, in the but-for test, you have to understand just what it means to discriminate. In Muldrow, right, it's not exactly in that space, but it's talking about you have to have some harm. If you don't have a harm, you can do all the but-for tests you like, but if there's no harm, if you're not injuring someone, you're not discriminating against them. So I do think there are permissible distinctions that don't cause harm, and that is, I think, where you get all the space for biologically based sex differences.
Although I think in the race discrimination context, we do assume that any type of distinction is harmful.
Yes, rightly so.
Because of the cultural context in which our discrimination laws were passed, whereas, with women, that's not true.
Thank you all for being here today. This is Seth Lucas from the Heritage Foundation. My question goes back to the original discussion at the beginning about the conceptual relationship between gender and sex and the implications of that relationship for our understanding of non-discrimination law. As conservatives seem to understand gender to be more of a phenomenon of how we live out, whether we're male or female, but in the modern day, it's beginning to be understood as a symbolic language in which things like hair length or makeup are more symbolic. We give meaning to these things, and we can mix and match things like body parts and symbols of sorts to construct entirely new gender identities, making it 10, 15, 50 gender identities. So the question is, could it be argued that those who do not accept this modern conception of gender actually have no gender at all, and in fact have very different identities, even though they use the same words to describe themselves as someone who uses the language of gender? And if that is the case, is it wrong to say, as Bostock said, that a man who identifies as a woman has the same identity as a woman who simply lives as a woman, and therefore that the two are not comparable?
I just think we should simplify everything and get back to basics and use the words that are clear. And so I think when we're talking about discrimination against men or women, we should call that sex discrimination, because that's what it is. If you're treating somebody adversely because they are a woman, or because they are a man, that is sex discrimination. That is not gender discrimination, and we need to just stop saying it. Gender is a made-up word from the postmodernist era, and it's basically, I mean, you can use it to describe certain things like stereotypes and cultural norms, but I'm not saying you should never use the word, but the reality is that the word entered our common lexicon because people who want to deconstruct sex were pushing that word. That's the main reason it entered our lexicon. I mean, also for the practical reason that people don't like to say sex, right? And there's, I always talk about this, I know Professor Coleman mentions this in her book, but there's a scene in the Ruth Bader Ginsburg movie On the Basis of Sex where she's writing her brief and her secretary is typing the brief, and the secretary comes to then Professor Ginsburg and says, I've been typing this brief and you use the word sex and sex discrimination like 100 times, and I just think it's going to be really distracting to the three judges on the panel who are men, so could we change it to gender discrimination? And Professor Ginsburg agrees to do that. Now, I have no idea if that ever happened or if that's just an anecdote that was, fictionalized for the movie. But I do think it illustrates our common sort of squeamishness with saying the word sex, and we got to get over it.
Hi, Evelyn Portier. I have a question for the panel and the gentleman who mentioned that Congress should act to clean up this mess. You talk about accommodation and fairness. So what is fair? I think we can agree that maybe in prisons, the warden should decide the safety of his prisoners and what is justified. And nobody's going to object to small children playing together on a team regardless of gender. But what happens for the transgender athlete? Like, what is fair? Should they just, as a blanket matter, not be allowed to compete in women's sports? Or, should you have a rule that's based on whether they had hormone therapy before puberty? I mean, how do you sort this out? What would your guidance to Congress be?
Well, I think Professor Coleman has a lot of things to say on that, but I just want to start by saying that elite sports aren't fair. They're not supposed to, they're fair in the sense of everybody plays by the same rules, but not everybody has a right to play an elite sport, to make a varsity team, to be recruited to be a college athlete, or to be in the Olympics. I don't have a right to, I have a right to try to do that, but I'm never going to be able to do that. So, you know, if it means that they can't live out their dream of being an Olympic female, you know, women's swimmer, then that's what it means, because lots of us can't live out that dream.
I'll just add that, that we have to remember that sports is actually an umbrella term that covers a whole lot of different sports settings, and some of them are competitive, some of them involve bodily contact, others don't, right? Some of them are competitive, some of them are not being like recreational sports, for example, where competition isn't the goal, where, for example, health and human development are the goal. And then there are contact sports and non-contact sports. There are sports in and out of school. Sports is this big umbrella concept, right, that you can apply to lots of different settings. And each setting has its institutional goals. We have separate sex sport in competitive settings because of physical sex differences between males and females. We don't have separate sex sport for other reasons. And so when those physical differences between males and females are not central to the enterprise, are not the focus of what we're doing, then that's when you see already, you see everyone can play kinds of situations. You don't see a real effort to separate boys and girls in those contexts. And so I think we always have to be driven by the rationale for and the mission of the enterprise, the rationale in each different setting, and that happens to fit, by the way, the equal protection analysis, right? You're not going to pass constitutional muster if your eligibility rule doesn't match up to your goal. And so if the goal has nothing to do with competition, talking about competitive differences between males and females is not going to justify your inclusion or exclusion rule.
I think we're a little over time, so I guess we'll just thank the panel and continue the discussion in the hallway.
Well, that's okay. I only got up because the Heritage Foundation said something about hair length, you know, and I said, I rise to, yeah.